Right now, 4 corporations control 56% of every seed planted on Earth. And in 2013, the Supreme Court of the United States handed them the legal framework to keep it that way, unanimously. 9 justices, 0 dissent. That ruling said that planting a seed grown from your own harvest, is an act of manufacturing without a license. And it is still the law of the land today, as you watch this. This video is about how that ruling was built, who built it, and what it means for every person who grows food or simply buys it. By the end of this video, you will also understand why food stopped tasting the way it used to. That answer lives inside the same system. Let's start with where things stand right now, because the full picture should stop you cold. 4 companies: Bayer, Syngenta, Corteva, and BASF. More than half of every seed planted on Earth, from commercial farms in Iowa to smallholder plots in rural India, traces its legal ownership back to one of those 4 corporate structures. Those same 4 companies also control 61% of the global pesticide market, seed and chemical. Same 4 boardrooms. We will come back to why that matters. In the United States specifically, over 90% of soybean acreage and more than 80% of corn acreage is planted with patented seed varieties. What that means practically is that the non-patented commercial option, the seed a farmer could legally save, replant, and share, has effectively ceased to exist at any meaningful scale in American agriculture. And every single one of those patented seeds comes attached to a contract. You can grow it. You cannot save it. You cannot share it with your neighbor. You cannot set aside a portion of your harvest to plant next season. When the crop comes in, the seed's legal usefulness to you ends, and next spring, you go back and buy it again. Now here's what makes this remarkable. None of this happened overnight. It was built piece by piece over 50 years, and the first piece was planted long before most of today's farmers were born. To understand what was taken, you first have to understand what existed before it was taken. For 10,000 years, seed saving was not a technique or a strategy. It was simply what farming was. You grow a crop. You harvest it. You select the strongest, most productive seeds from that harvest. You dry them, store them, and plant them next season. Every civilization that has ever fed itself did this. It was the mechanism by which agriculture improved, farmers selecting for drought resistance, for yield, for taste, for the specific conditions of their specific land over generations. The seed was not a product. It was a living inheritance that farmers developed, refined, and passed forward. That began to change in 1970 when the U.S. Plant Variety Protection Act extended intellectual property protection to seeds for the first time in American legal history. The public framing was straightforward: protect agricultural innovation, incentivize investment in crop development. What the law also did, quietly, was begin constructing a legal framework in which a living organism could be owned. And this is where the timeline gets interesting. In 1980, a Supreme Court case called Diamond versus Chakrabarty went further than anyone in agriculture had anticipated. The case did not involve seeds. It did not involve farming at all. It involved a microbiologist named Ananda Chakrabarty, who had engineered a bacterium capable of breaking down crude oil. The question before the court was narrow. Can a living organism be patented? The court said yes, 5-4. The agricultural industry understood the implication before the ink was dry. If a bacterium could be patented, a genetically modified seed could be patented. If a seed could be patented, saving that seed was patent infringement. The entire legal architecture that governs farming today, every contract, every lawsuit, every courtroom ruling you will hear about in this video, rests on that one 5-4 decision made by 9 justices who were not thinking about farming at all. And once that door was open, one company understood faster than anyone else exactly what to do with it. Monsanto's entry into the seed business is one of the most deliberate corporate pivots in modern history. The company had spent decades as a chemical manufacturer, Agent Orange, PCBs, Roundup. In the 1990s, it saw what the Chakrabarti ruling had made possible and moved with precision. In 1996, Monsanto launched Roundup Ready soybeans, the first commercially available genetically modified seed engineered to survive direct application of glyphosate, the active ingredient in Roundup, Monsanto's own herbicide. The innovation was real. Farmers could spray their fields directly without killing the crop. Yields improved. Weed management became simpler. Adoption was fast. But the business model underneath the innovation is where the story gets interesting. Roundup Ready seeds were engineered to perform optimally in combination with Roundup herbicide. Buy the seed, and you buy into the chemical. The two products were not designed independently. They were designed as a system. And that system belonged entirely to one company. Then, Monsanto began buying the competition, not gradually, systematically. Holden's Foundation Seeds, which supplied genetics to roughly 35% of the U.S. corn seed market. DeKalb Genetics, one of the largest independent seed companies in the country. Asgrow. And then Seminis, at the time, the world's largest vegetable seed company, controlling roughly 40% of the U.S. market for tomato, pepper, and lettuce seed varieties. Each acquisition removed an alternative. Each one narrowed the field. Think about that. If you wanted to grow a tomato in 2005, there was a 40% chance your seed came from one boardroom. By 2005, according to research published by Philip Howard at Michigan State University, the top 10 seed companies controlled less than 30% of the global seed market. By 2018, 13 years later, 4 companies controlled more than half. That pace of consolidation has no precedent in the history of the food supply. And here's the part that regulators saw but could not stop. When Bayer acquired Monsanto in 2018 for $63 billion, antitrust law required Bayer to sell off certain overlapping assets. Those assets went to BASF. The regulators treated this as a remedy. What it actually did was hand the third largest agrochemical company in the world a direct upgrade, using Monsanto's own divested portfolio. The consolidation did not break up. It redistributed among the same 4 players and closed tighter. Now, follow the money, because this is where it leads. Owning the companies was never sufficient on its own. To make the ownership permanent, to ensure that a farmer could not simply save seed and step outside the system, the corporations needed the courts, and they got them. Monsanto's technology agreement, which every grower purchasing its seeds is required to sign, is explicit. The grower agrees to use the seed for planting a single commercial crop only, not to supply any seed to any other person for planting, and not to save any crop produced from the seed for replanting. The contract reads less like a product license and more like a lease. You are not buying the seed, you are renting the right to grow it once. To enforce that agreement, Monsanto built what critics began calling the seed police, an internal investigations unit that monitored farming communities, reviewed purchasing records, and pursued suspected violators. Since 1997, Monsanto filed 147 lawsuits against American farmers, collecting more than $23 million in settlements and judgments from individual growers and small operations. That figure comes directly from Monsanto's own public statements. In 2008, the company sued Maurice Parr, not a farmer, but a seed cleaner, a man whose job was operating equipment that cleaned harvested seeds for replanting. Monsanto's claim was that by providing his services to farmers who saved seed, Parr was aiding and abetting patent infringement. A seed cleaner sued for helping farmers do what farmers had always done. You might think, I will just never sign their contract. But as one farmer in Canada found out, the law does not care if you signed anything. All it takes is the wind. Percy Schmeiser had been farming canola in Saskatchewan for over 40 years. He had spent decades selecting and developing his own seed varieties, adapted specifically to his land and his growing conditions. In 1997, Monsanto's patented canola appeared in his fields. He had not purchased it, had not planted it. The scientific evidence presented in court suggested the seeds had arrived on his land through wind drift from neighboring farms or carried by passing vehicles along the road bordering his property. Nature had moved the seed. Percy Schmeiser had done nothing. Monsanto sued him for patent infringement. The case moved through the Canadian court system for years. The Canadian Supreme Court ultimately ruled that the exclusive rights of a patent holder over plant genetic sequences extend to the plants themselves, meaning that regardless of how Monsanto's DNA arrived on Schmeiser's land, its presence there was governed by Monsanto's patent. A corporation's genetic material drifted onto a man's land without his knowledge, without his consent, without any action on his part. And the highest court in Canada determined that he bore legal responsibility for what nature had carried. That is not a hypothetical. That is not a worst-case scenario someone invented to make a point. That is a documented ruling from a Supreme Court, still cited in agricultural patent law today. If you have never heard Percy Schmeiser's name before, you are not alone. Most people who grow food, whether on a commercial farm or in a backyard garden, have no idea this legal framework exists or what it has already decided about their rights. This channel exists to change that. Subscribe to Harvest Origins, because the next video in this series follows the trail deeper into the movement that gave corporations the political cover to build all of this. You will want to be here for it. Now let's talk about what this system actually costs, not in legal fees, but in the everyday economics of growing food. A 2019 analysis by the Farmers Business Network found that U.S. corn seed prices increased by 259% between 1990 and 2015, a period during which the number of independent seed companies declined by more than 200. The correlation is not subtle. Fewer sellers, higher prices. That is not an agricultural phenomenon. It is a basic market outcome when competition is removed. The USDA's own data shows that American farmers now allocate a significantly larger share of operating expenses to seeds than they did 3 decades ago, an increase that has not been matched by proportional yield improvement across the industry. The farmer is paying more. The return is not keeping pace. For smallholder farmers in India, Brazil, and sub-Saharan Africa, the impact arrived differently, not as a price increase, but as a disappearance. The local seed networks that communities had maintained for generations were displaced as corporate seed distribution expanded into markets where regulation was limited and alternatives were not defended. And for anyone growing food at home, here is the number that puts the entire picture in focus. The Rural Advancement Foundation International documented that of the vegetable varieties listed in commercial U.S. seed catalogs in 1903, approximately 93% had been dropped from those catalogs by the early 1980s, as the consolidation of the seed industry began accelerating. Those varieties were not replaced. They were not improved upon. In most cases, they simply ceased to be commercially available. The diversity that farmers had cultivated across centuries was quietly retired because it could not be patented, could not be controlled, and had no place in a system designed around annual repurchase. Now, some people watching this will say, this only affects commercial farmers growing GMO crops. If you buy heirloom seeds or open-pollinated varieties, you are outside this system entirely. And that is partially true. The patent enforcement, the technology agreements, the lawsuits, they target commercial growers using patented varieties. But the variety extinction data does not make that distinction. The consolidation of the commercial seed industry removed open pollinated diversity from the market regardless of whether anyone was farming with patented seed. The infrastructure that sustained that diversity, the regional seed companies, the public breeding programs, the university variety trials, was dismantled or defunded as the corporate model became dominant. The home gardener was not sued. They were simply left with fewer options every decade, without ever being told why. The reason your grandfather's tomatoes tasted the way they did is not nostalgia. It is that the variety he grew quite possibly no longer exists anywhere on Earth. The price increases, the variety losses, the disappearing seed networks. Each of these looks like a separate problem until you understand the architecture underneath them. And once you see that architecture, what looked like a series of market outcomes starts to look like something that was designed because it was. Roundup Ready seeds were engineered specifically to survive glyphosate. Buy the seed, and you are entering a chemical relationship. The herbicide that kills every other plant in the field leaves your crop standing, because your crop was built to survive it. That engineering is genuinely useful. It is also a lock. Because once your operation is built around Roundup Ready varieties, transitioning away from glyphosate requires rebuilding weed management systems your farm may not have used in decades. When Bayer acquired Monsanto, it acquired both sides of that dependency simultaneously, the seed and the chemical that the seed requires. The same pattern holds across the industry. The four corporations that dominate the seed market also dominate the pesticide market. Seed and chemical, owned by the same structure, sold as a system, renewed every season. For a farmer inside the system, exit is not a product decision. It means rebuilding soil biology that years of synthetic chemical dependency have altered. It means sourcing open pollinated varieties that commercial distributors have largely stopped stocking. In some cases, it means relearning cultivation practices that the industry spent 50 years convincing farmers were inefficient or obsolete. The system was not designed to feed the world. It was designed to make the world dependent on it. And by every available measure, market concentration, legal precedent, price trajectory, and the quiet disappearance of agricultural diversity, it has succeeded. What you just watched is one layer. The corporations did not build this legal and economic architecture alone. They had help from governments, from international development institutions, from a humanitarian movement launched in the 1960s that publicly claimed to be solving world hunger and privately created the conditions that made all of this possible. The next video follows that trail. The further it goes, the less it looks like charity. If this investigation matters to you, share it with one person who grows food or buys it. That is how this kind of information travels. The next video is right here.